Okay, let's get started with our next panel, which is about the Whistleblower program. It's called Whistleblower Update, the impact on corporations and SEC enforcement. And our moderator today is Sean Prosser. Sean began his legal career in the SEC's Division of Enforcement. He's now a member of Mintz, Levin, and their Securities, white-collar, and litigation practice, with decades of success before the SEC and many other state and federal enforcement agencies. I urge you to check out Sean's list of representative matters on the Mintz website. It is an amazing track record. Welcome, Sean.
Thank you, Bruce.
Also like to introduce Hardy Callcott. Hardy is a partner at Sidley Austin in San Francisco, and his illustrious career also includes previously serving as General Counsel of Charles Schwab, as well as Assistant General Counsel for the SEC's Market Reg Division. And Hardy's practice concentrates on enforcement events and regulatory counseling for the financial services industry. Good to see you, Hardy. Welcome. Pleased to welcome Kristin Flinn. She's an associate director at Berkeley Research Group, and she'll offer a different perspective to this panel in that as a CPA and a certified fraud examiner, her focus on forensic investigations and financial statement analysis and accounting guidance will be a key thing to keep in mind in these whistleblower discussions. So welcome, Kristin.
Thank you.
And then finally, our next panelist is from the SEC, Kate Zoladz, who is Associate Regional Director who oversees the SEC's LA office enforcement efforts in Southern California, Arizona, Hawaii, Nevada. She started out as a staff attorney in 2010 and then spent time in the asset management unit after that. But she's continued her rise through the SEC ranks to her current very senior position, and it's really great to have Kate with us today to hear her perspective. Welcome.
Thank you, Bruce.
Thank you.
Hello, everyone. Thanks for being here in person. Kate, thank you for being here from the SEC. I know everyone appreciates it. Whistleblowers, it's that word that in-house counsel, CEOs, outside counsel, when they hear it, they cringe a little bit. Everyone's favorite topic, and the SEC's office is getting very, very active now on some of these cases. It's hard to believe that the SEC whistleblower program began more than a decade ago. It seems new. It still feels new to me because I think there's so much that's unknown about the internal process. Kate, I was wondering if you could just remind everyone an overview of what the program is.
Sure. Well, this first question is not particularly controversial. I'm going to forget if I don't say it now. So the views I express today are my own and do not necessarily reflect the views of the staff, the commissioners, or the agency. So I think most of you are probably pretty familiar with the whistleblower program, but it was established by Congress in connection with the Dodd-Frank Act. At a high level, it authorizes the commission to pay an award of between 10 and 30% of amounts collected where an eligible whistleblower voluntarily provides original information that leads or significantly contributes to a successful enforcement action where monetary sanctions exceed $1 million. So that's just high level. So in terms of process, so the awards are posted and the whistleblowers have to actually apply for the awards. The Office of the Whistleblower at the SEC reviews each application and they make a preliminary determination of whether the whistleblower is eligible, and if so, where within that range they fall. So just to be clear, though all awards are actually approved by the Commission, not by the Office of the Whistleblower. And payments, of course, don't come from disgorgement or other monies that are intended to compensate investors. They come out of the Investor Protection Fund. The Dodd-Frank Act also expands the prohibition against whistleblower retaliation. So an individual can bring a private right of action in district court against their employer for retaliation under Dodd-Frank. And in addition, the commission can bring an enforcement action against a company for violations of these anti-retaliation provisions. And finally, just by way of summary, the Dodd-Frank Act also provides that an enforcement action may be brought against a company who takes any action to impede an individual from communicating directly with the commission about a possible securities law violation. So that would be things like enforcing or threatening to enforce a confidentiality or other similar agreement.
Thank you for that overview. From my perspective, it felt like the SEC program, it started off slowly, that there weren't a lot of awards, there wasn't a lot of activity, at least publicly, that that we see. But more recently, it really seems to have picked up steam. I'm wondering if you can give us an overview of the recent activity.
Yeah, sure. I mean, I think I would definitely agree that the whistleblower program has been pretty active lately. Last fall, it passed the $1 billion mark in awards to whistleblowers since the first award in 2012. And a lot of this activity has occurred over the past year or so. So fiscal year 2021 saw the highest number of awards to whistleblowers, both in terms of dollar amounts and the number of individuals. The commission actually made more whistleblower awards in fiscal year 2021 than in all prior years combined. So let me break that out and give you some actual numbers on that. So in fiscal year 2021, the SEC awarded approximately $564 million to 108 individuals. And 4 of the top 10 highest whistleblower awards were issued in that year, including a $114 million award in October of 2020, two $114 million awards to 2 individuals in September of 2021, a $50 million award to joint whistleblowers in April of 2021, and a $36 million award to an individual in September of 2021.
Well, that's it. I'm changing my career. I'm officially going to be a whistleblower. I will, just a quick anecdote, I'm aware of a situation where a former employee of someone posted on their LinkedIn page that their activities and says SEC whistleblower on so some people are very happy to be whistleblowers. Hardy, there have been some amendments to the program in recent years, originally under former Chair Clayton in 2020, and then recently some proposed amendments by the current chairman. I wonder if you could give us an overview of those and potential impact.
Yeah, so the first set of amendments under Chair Clayton actually goes back to a Supreme Court case, Digital Realty Trust v. Summers, where the Supreme Court actually threw out one of the SEC's whistleblower rules. You know, the SEC had tried to protect people who were internal whistleblowers at their company before they had gone to the SEC, and the Supreme Court said that that was not authorized by the statute. So the SEC kind of had to go back and redo some of the definitions. They took the opportunity to do a fair amount of sort of administrative clarification. For example, added the ability to bar people who make repeated frivolous whistleblower claims from making additional whistleblower claims, adopted sort of streamlined provisions for whistleblower claims that didn't have any substantiation. I think with the intent to streamline and make faster the whole process of getting the claims actually paid out to the whistleblowers. There were also some rules, sort of clarifying when you have to file what forms, what are the consequences of not filing the forms. The most controversial part of the Clayton amendments was the SEC said for very large claims, the SEC could reduce the amount of the payout, from, the sort of top end of the range, the 30%, closer to the middle or lower part of the range, the 10%, so that there would be more money in the fund to pay whistleblowers in smaller whistleblower cases. That was very controversial, and the Gensler proposed amendments, which are out for comment, well, actually, I think the comment period is closed, but were proposed since Gensler came in, would repeal that and say we're not going to make that differentiation between large claims and small claims because we don't want to deter the large claimants from making their claims and otherwise sort of generally decrease the amount of discretion. I mean, the SEC under Clayton had said, we have discretion to balance all of these different factors. So, Kate, I don't know if you have a perception on how the administrative amendments have affected the Commission's ability to make those whistleblower payments.
So I do think you're right. The purpose of that was to increase transparency and efficiency, and I think it worked. So, we had obviously an increase in the awards that we've talked about. The Office of the Whistleblower processed more claims in fiscal year 2021 than in any other year in the program. It issued the largest number of final awards, both awarding money and denying awards, and I think that was in large part due to the 2020 amendments that you discussed. So the barring of claimants who make 3 or more frivolous claims, the presumption of setting a 30% payout for awards under $5 million, a summary disposition process for straightforward denials. So those efficiencies, I think we are seeing the results of that, just in more claims being processed, more awards.
Yeah. Well, let me just ask one more numbers-related question. To me, in the last year's whistleblower report, the number that really jumped out at me was the number of whistleblower tips that came into the commission went up by 76% in 1 year. And ever since the Madoff situation, the SEC has been under a lot of pressure. If we get a whistleblower tip, unless it's really bad, really obviously not meritorious tip, we should spend some time investigating. Now, I know the SEC's enforcement budget and staff did not go up 76% last year. How do you balance figuring out which whistleblower tips to pursue and not, and in a era of limited resources?
Let me just be clear, it'd be great if our budget did increase by 76%, so just make a plug for that here. But obviously it didn't, and I think we're always working in a world of limited constraints. I would just point out that not all 12,000 of those tips come directly to enforcement. I mean, it is triaged by the Office of Market Intelligence, and they're going to be passing on the most timely, the most credible claims. It's a facts and circumstances determination where we're looking at, what availability do we have, dollar amounts, we're looking at ways to prioritize that. But it kind of is very much a facts and circumstances analysis of any particular claim, of how credible it looks, how much damage is. We're kind of making those determinations all the time about what to pursue.
When a company gets wind that there's been a whistleblower, or they get an inquiry from the SEC and it feels like, okay, this is arising as a result of a whistleblower, it's a difficult situation and the company needs to do something and counsel needs to do something, but what can they do? The SEC has all these scary rules in place against retaliation. Kristin, I'm wondering from your perspective as a forensic accountant, and you've been involved in internal investigations, what are some best practices that companies should do if they're confronted with a whistleblower internally?
The best practice that I'm going to mostly focus on today is that when you are opening an internal investigation, or if there's a suspected whistleblower, cast a wide net to identify other internal control deficiencies, because we've seen often that whistleblower claims lead to the discovery of internal control failures, especially failures surrounding internal controls over financial reporting, which is referred to as ICFR. And in case anyone doesn't know what ICFR is, those are controls that executives rely upon for reliable published financial results, like financial statements filed with the SEC. So we often see that even if the whistleblower claims are sometimes slightly off the mark, it usually points to bigger internal control problems at the firm, with segregation of duties or reporting systems, which is why we say cast a wide net. It's kind of the saying where there's smoke, there's fire, but the fire may be bigger coming from somewhere else in the organization than what the whistleblower had found. And in a recent whistleblower case that we worked on, a whistleblower within the accounting department claimed that management was making improper adjustments to a non-GAAP measure. So the claims led to an audit committee investigation, and through the investigation it was found that while adjustments had been being made, there were legitimate reasons for every material adjustment that had been made, and those reasons had just not been made clear to the whistleblower. But the investigation brought to light many other internal control deficiencies, such as inadequate or non-existent accounting policies and procedures surrounding non-GAAP measures, inadequate accounting personnel expertise, and inadequate training of that personnel. And in one other recent case that I'll give an example, a whistleblower from the internal audit department at an insurance company found improprieties in the insurance company's accounting. And that also led to an investigation, and through the investigation it was found that the whistleblower just didn't understand the accounting rules behind the transactions that had been made, but it brought to light some other significant internal control failures, such as the CFO was able to approve and execute his own trades on behalf of the company. There was inadequate controls surrounding the preparation of trading data at the firm, and also inadequate training of their accounting personnel.
Kate, you had mentioned the increasing awards, and Hardy mentioned the real increase in the number of tips. I'm wondering, what's the reason for it? Why is the SEC suddenly coming out with much, much larger awards, and then suddenly it's fueling more tips, or is it fueling? Are they connected at all?
So I don't know that I can opine on like cause and effect, but certainly we are seeing more awards. We are seeing a huge number in the increase in tips. So as Hardy mentioned, a 76% increase from 2020 to 2021, and it's a 300% increase since the beginning of the program. So that was over 12,000 whistleblower tips. So I'm not sure I can opine on cause and effect, but there's certainly causation, correlation. It certainly is an increase.
Okay. Hardy, there's been some discussion there, I think maybe some discussion later today too, about Commissioner Pierce issued a rare public dissent related to a whistleblower case, the Hansen matter. I'm wondering if you could give us an overview of that and really what does it mean? Because you don't typically see, commissioners putting out their own statements sort of against things that are going on.
Yeah, and just to follow up on the sort of what do you do when you get a potential whistleblower, from a legal perspective, the first advice you always give is don't retaliate, don't impede communications with the SEC. And there are cases where the SEC has proceeded against companies or against individuals where there was retaliation or impeding of communications with the SEC, even without the whistleblower actually having found a valid SEC violation. So you can violate those anti-retaliation and impedance, if that's a word, provisions, even without an underlying securities violation. So anyway, the case that Sean just mentioned is David Hansen, and as with all SEC settlements, the actual complaint is a little bit telegraphic about what the underlying facts are. The Hansen was the chief information officer of a technology company, and someone came to him claiming that the company was exaggerating its number of customers, and the individual threatened to take that information outside the company to anyone who was interested, vendors, suppliers, competitors. And so the CIO, not entirely surprisingly, decided to delete the guy's administrative access to company computers, although left him with read-only access. Also gave a copy of the guy's computer to the CEO with the person's password, and anticipating that the CEO would look at what the person's activity was on that computer. Anyway, the SEC alleged that this impeded the whistleblower's ability to communicate with the commission. And what Commissioner Pierce said was, it's not obvious on those facts that that did, in fact, impede the person's ability to communicate with the commission. She said, it just, on its face doesn't state a claim for the violation that is alleged. Anyway, there's a whole set of cases over the past, not just last year, but over the past 5 or 6 years, where the commission has brought cases under these, retaliation and impedance theories. And some of them are fairly straightforward policies that say, you can't communicate information outside the company, you can't share intellectual property or trade secrets with anyone outside the company without getting permission, and similar provisions in severance agreements. And the commission has alleged that, okay, those, because they didn't have explicit carve-out saying, oh, but of course you can communicate with the SEC, we don't mean to tell you you can't communicate with the SEC, that those violate the restrictions on, as I say, impeding communications with the SEC. None of those cases have been litigated. They've all been settled. So I think the law, what actually constitutes retaliation, or especially impeding communication with the SEC, is still a little unsettled here. But what we always urge people is be very careful in drafting those policies and drafting those severance agreements to make it clear that you're not suggesting that anyone is restricted from communicating with the government about anything that the government wants to talk to them about or that they want to talk to the government about. So, and what I would say from my clients is in the regulated community, sort of the broker-dealers, investment advisors, I think a lot of clients have gotten that message. I'm not sure in the broader issuer community that people have entirely gotten that message, but I just flag for you that actions that can appear fairly benign, you know, cutting off somebody's computer access, you know, you have to be careful about how you do it, how you justify it, how you document it, and whether you do it if you've got a potential whistleblower. And by the way, I don't think there's any allegation in the Hansen case that the CIO knew that the person was in fact a whistleblower or had any intent to hinder that person's ability to communicate with the commission. And in prior settlements, the SEC has suggested that those are not elements of the offense. If you do something that has the effect of impeding communication, that's enough to be a violation.
It's a tricky situation because sometimes, like you said, you don't know who the whistleblower is. You're doing your normal work. What if you're going to have a reduction in force? You're going to start firing people. It's a very, you got to be a very deliberate and careful process when you're making personnel changes when you know that there's an SEC investigation going on or a whistleblower and things like that. But you're also going to want to internally investigate, so you have to navigate that very carefully. And Kristin, I'm wondering, you had mentioned internal controls, so in connection with the, you know, the internal accounting mechanisms, what tools are there to help companies identify deficiencies that they may have?
So the tool that we use, there's an internal control framework called the COSO framework. And COSO stands for Committee of Sponsoring Organizations of the Treadway Commission, and it sets out requirements for effective internal control. And the framework can be used during a whistleblower investigation to help identify internal control failures. It's the accepted guidance in the U.S. on internal controls, and you'll see most public companies disclose that in their filings with the SEC. Something like management has evaluated our internal controls and the effectiveness of those controls under the COSO framework. So the framework provides 5 components of effective internal control that must exist. The first being control environment, and that is the atmosphere where people conduct their activities and carry out their control responsibilities. And this encompasses the tone at the top of an organization. Risk assessment is the second, and this is just saying that management should assess risks to the achievement of internal control objectives. The third is control activities, which are actions established by policies and procedures to help ensure that management directives to mitigate risks are carried out. The fourth is information and communication, which says that relevant information should be communicated throughout the organization in a timely manner. And the fifth is monitoring, which is that the entire process should be monitored and modified as conditions warrant. So these 5 components, along with 2 other categories of objectives of internal control, are often presented as a 3D cube called the COSO cube. And the cube is a tool available for lawyers, accountants, anyone. We use it during whistleblower cases to help identify and assess the effectiveness of internal control. So somewhere this internal control process broke down to produce a whistleblower. So for example, in the first case that I mentioned before, there was a breakdown in the information and communication component of the framework because the whistleblower in the accounting department just hadn't been made aware of the business reasons behind the adjustments being made. And then through the investigation, when additional internal control deficiencies were identified, like inadequate policies and procedures surrounding non-GAAP measures, that's a breakdown in the control activities component of the framework. And similarly to the second case that I mentioned, inadequate control surrounding trading data is also an example of the control activities component breaking down. And finally, in both of the cases I mentioned, they also both highlighted the fact that there's inadequate training of accounting personnel to identify true accounting errors. And training falls under the control environment component of the framework. So that's an example of the control environment breaking down. And if that had been in place correctly, those whistleblower claims likely could have been avoided entirely.
And I'll just follow up to say, some of that was about internal controls over financial reporting. There's also a separate concept, which is internal controls over disclosure. And I think one of the things we have seen in the past few years from the SEC is cases where, the company got the accounting right, but the SEC alleged that there were disclosure failures, in the management discussion and analysis. And so, you need to have internal controls over both financial reporting, but also disclosure controls.
Yep.
And as I say, the SEC has been, I was involved in a case last year where the accounting was absolutely right, but the SEC alleged that, the firm had not disclosed some known trends and uncertainties. And so I'll just urge you to think about, when you think about internal controls, don't just think about accounting, think about disclosure controls as well.
Good point.
We got a question from the audience. Thank you for that, Kate. It's similar to something I was going to ask. Everyone wants there to be a circumstance where people can report problems and not have retaliation. But I'm also, and I'm personally aware of situations where a disgruntled former employee made whistleblower complaint that turned out to be 100% false. And the question the audience member had is also, what's the SEC's view when the whistleblower turns out to have been a participant in the fraud or involved, and it's almost like a CYA complaint to the SEC. So I'm wondering what protections are there for companies, in these situations, because it's a very serious circumstance when the SEC contacts you. There's a whistleblower. You're right. You have to spend lots of money and lots of time and a lot of time with lawyers to convince the SEC that there's no merit to this claim. What protection do companies have?
Sure, and I think I would just kind of distinguish two situations that you're sort of getting at there, where the whistleblower may have been a participant, but there was something actually to blow the whistle on there, and then the situation where it's just like an entirely false claim. So in the second situation where it's just something completely false, I would just note that the whistleblower program does have protections for companies in place. I think most significantly, to be part of the SEC's whistleblower program, they're required to submit their tips under penalty of perjury. So that is a significant protection right there. Also, obviously whistleblowers who knowingly provide false information are not eligible to receive an award. And of course, the awards are only given if the tip pans out and there's a successful enforcement action. So presumably that's not going to happen if someone's submitting something that's false. I would just note that just because we don't bring an enforcement action in a case where there is a whistleblower, that doesn't mean the whistleblower submitted false information. Could be a myriad of reasons why we wouldn't pursue the claim. But certainly if there's false information and the company has shown that there's false information, we're not going to be pursuing an enforcement action.
Thank you.
Yep. And I'll note, though, on the participants, some of us, I helped draft a trade association comment letter on whistleblower rules when they were first adopted. Some of us argued that participants shouldn't be eligible to get whistleblower awards, and the commission specifically rejected that and said, sometimes participants can provide valuable information. Rather, what the commission said was, it's a factor they would take into account, and maybe if you were a participant, you would be on the lower end of the 10 to 30% payout as opposed to the higher end. And anyway, it's very hard because the other thing about the whistleblower program is the SEC has very strong guarantees of confidentiality for whistleblowers. You never know who the whistleblower is unless you end up in a litigated proceeding with the commission where they put the whistleblower on. In a settlement, you never find out, and the commission staff is legally forbidden from telling you. So it's very hard to tell who the whistleblowers are and what their role, if any, was in the underlying conduct. But it is certainly potentially possible that a participant, even a central participant, can then turn themselves into a whistleblower and receive an award as a result, which creates, at least in theory, some potentially perverse incentives. Now, I'm not sure we've seen those perverse incentives play out, but it is, as I say, we can't really know because of the fact that it's all confidential.
Yeah, it's an interesting dynamic when the company or counsel, there's a whistleblower and who it is and what he complained about, but the SEC staff can't really even acknowledge as a whistleblower. They can't identify what it is. So they issue these requests like, let's look at these 10 transactions, but they're looking at 3. So then, it kind of cuts to the chase, like, okay, I know you're looking at these 3, and let me explain to you why those are right. And then the SEC can't really acknowledge it, and they go, okay, let's focus on those 3, but they don't want to acknowledge that it's a result of the whistleblower complaint. We have just a couple minutes. I'm wondering, for everyone, what are you seeing over the next year? What are any predictions or expectations in the SEC whistleblower program? Kate?
I can start that. So I think we're going to see more awards. I think we're going to see more tips. I think we're going to see a lot more activity out of the whistleblower program.
Okay, Kristin?
I know cryptocurrency fraud is obviously a hot topic right now, and an increased focus of the SEC. And that is in part due to the fact that there's currently no authoritative accounting guidance on accounting for cryptocurrencies. Right now, it's largely a disclosure requirement. Disclosures require a lot of judgment, and with disclosures come a lot of regulatory scrutiny. And I was reading the other day that the SEC's crypto assets and cyber unit is doubling in size in response to all the cryptocurrency fraud and markets that are growing. And I think whistleblowers are going to play a key role in the success of that unit and in bringing to light the cryptocurrency frauds. So I think that we'll see a lot of that in the coming year.
And I guess my prediction would be the rule proposals that Chairman Gensler proposed for the whistleblower program, again, to sort of increase the presumption that awards are going to be sort of at the high end of the range and not reduce small awards. I think that's extremely likely to be adopted. You've got a commission right now that is very, very pro-whistleblower and wants to encourage whistleblowers to the maximum extent they can. And to the question of, what are some of the structural reasons for this? I mean, there has grown up a very substantial whistleblower representation bar. And, there are people out there advertising for whistleblower cases, and some of them are very smart and sophisticated lawyers. And I think that is encouraging people who might have been on the fence to go ahead and get representation and make sort of better quality complaints, better quality tips to the SEC, as opposed to just people coming in off the street to the SEC.
Great, thank you. We have just a minute or two left if anyone has any questions. Happy to address those. Okay. All right. Well, thank you very much, everyone. It's been a pleasure. Thank you.
Thank you, Sean. Thank you, panel. Great job. We'll be back at 11:05.